On October 15th, Milano asked women to use the hashtag #MeToo to give the world a sense of the magnitude of the problem of sexual harassment and assault. In less than 48 hours, the #MeToo hashtag had been tweeted nearly 1 million times. Within days, several very prominent men from a wide variety of professions were identified for engaging in sexual harassment and assault. Many of those individuals were subsequently fired or were asked to resign. Time magazine awarded its 2017 Person of the Year to the Silence Breakers. Tarana Burke, the creator of the #MeToo hashtag, and Milano were interviewed by various television stations and media outlets. Burke noted that this is just the start. I've been saying from the beginning, it's not just a moment, it's a movement. Now the work really begins. Today's presentation will discuss what constitutes sexual harassment, what constitutes retaliation. We will also discuss within the presentation and give practice tips for improving sexual harassment policies, how to conduct sexual harassment investigations, and how employers can create a more inclusive work environment that decreases the likelihood of sexual harassment in the workplace. Finally, we will discuss possible emerging issues in the area of sexual harassment. As I indicated earlier, please forward any questions that you have throughout the course of the presentation to us, and we will try to answer as many of those questions that we can at the end of the presentation. As a general matter, you should know Minnesota law provides broader jurisdiction than federal law. Courts have construed Title VII to only apply to employers with more than 15 employees in certain instances. The Minnesota Human Rights Act, however, applies to all employees as its application begins with the first employee employed by the company. The concept of sexual harassment under Title VII, the federal law, is a creation of case law, which means it is determined on a case-by-case basis by judges. The definition of sexual harassment, however, is embedded specifically within the Minnesota Human Rights Act. Another difference is that a complaint of sexual harassment under federal law must be filed with the Equal Employment Opportunity Commission before an individual files legal action in court. There is no similar requirement under Minnesota law. An individual could go right directly into court and allege a claim under the Minnesota Human Rights Act. Finally, the statute of limitations period under federal law is shorter than Minnesota law. Under Title VII, an employee must take action within 300 days of the act of discrimination. Under Minnesota law, an employee has 1 year from the act of discrimination to take administrative or legal action against their employer. With that background, let's begin with a definition of sexual harassment. Minnesota law recognizes two forms of sexual harassment. The first form of sexual harassment is known as quid pro quo. Quid pro quo is Latin for this for that, or something for something. Quid pro quo harassment occurs in the workplace when a manager or authority figure in the company hints that he or she will give the employee something, a raise, a promotion, in return for satisfaction of the sexual demand. Quid pro quo harassment can also occur when the manager or authority figure suggests that he or she will not fire or reprimand an employee in exchange for some type of sexual favor. A job applicant may also be subjected to this kind of harassment if the hiring decision was based on the acceptance or rejection of the sexual demand. So, for example, let's assume that a male bank manager interviewing a female applicant for a job as a teller places his hand on her thigh. When she objects, he asks, "Do you want the job?" This type of conduct or language would be an example of quid pro quo harassment. The second form of harassment is known as hostile working environment. A hostile working environment is created when the employee is subjected to verbal, written, electronic, or physical conduct that, 1, affects an individual's employment, 2, could also unreasonably interfere with the individual's performance at work, or 3, it creates an intimidating, hostile, or offensive work environment. A hostile working environment may include comments or physical conduct that is sexual in nature. Therefore, a manager that routinely texts and sends instant messages to her coworkers with sexually explicit jokes and pictures may create a hostile working environment. Sexually explicit conduct, however, is not a requirement to establish a hostile working environment. The Minnesota Supreme Court, in a case called Lamont versus Independent School District 728, held that an employee may bring forward a claim of sexual harassment even when the alleged conduct is not sexual in nature. Accordingly, ostracizing women and making them feel degraded in the workplace may be sufficient to create a hostile working environment, even when the conduct is not sexual in nature. That kind of begs a question for us, and that is, when does conduct reach the level of creating a hostile environment? In order for conduct to constitute a hostile environment, the conduct must be severe or pervasive to the point of altering the conditions of the alleged victim's employment to create an abusive work environment. In deciding whether conduct is so severe and pervasive, courts look at the totality of the circumstances surrounding the conduct. Well, what do courts mean when they say the totality of the circumstances? Here are the factors which have been laid out in Minnesota case law. Was the conduct welcome? Was the conduct an isolated incident, or was the conduct part of a larger pattern of conduct? The severity of the conduct. Was the conduct physically threatening or humiliating? Finally, did the conduct unreasonably interfere with the employee's work performance? A quick word here on the issue of whether the conduct was welcome. In determining whether the conduct was welcome, courts have held that the issue is not whether the employee alleging harassment participated in the sexual activity, but rather the issue is whether the employee indicated that the activity or sexual advances were unwelcome. In evaluating whether the conduct is so severe enough to constitute sexual harassment, courts apply a subjective and an objective test. The subjective test applied by courts is whether the victim personally believed the behavior was so severe and pervasive to constitute a hostile, abusive working environment. The objective test applied by courts is whether the average reasonable person would believe the behavior to be so severe and pervasive to constitute a hostile working environment. Therefore, in order for courts to find that sexual harassment occurred, the conduct must meet both the subjective and objective tests. Well, when is an employer liable then for sexual harassment? A company is strictly liable for sexual harassment when the individual who commits the bad acts is what is considered to be the alter ego of the company. An alter ego of the company is someone who embodies the company, such as the president or chief financial officer of the company. Strict liability means that the company is liable if the act was committed. Then there is liability on the part of the company. There are really no defenses available to the company in such situations. A company is also strictly liable for sexual harassment when a supervisor engages in sexual harassment and the employee suffers a tangible employment loss. A tangible employment loss includes failing to hire someone, denying a promotional opportunity, demoting or reducing someone's pay or benefits, or firing an individual. So again, that combination, tangible employment action by a supervisor, creates strict liability. Now, it does beg a question, then who is a supervisor for purposes? And this is where we see a little bit of a divergence between federal and state law. Federal law states, in a case called Vance versus Ball State, that quote, an employer may be vicariously liable for an employee's unlawful harassment only when the employer has empowered that employee to take tangible employment actions against the employee. Minnesota, on the other hand, creates a slightly broader definition of who is a supervisor. Under the Minnesota Human Rights Act, as interpreted by the Minnesota Supreme Court in Freeler versus Carlson Marketing Company, a supervisor is an individual who has the authority to direct an employee's daily work activities. So the idea of just being able to make assignments may be sufficient under Minnesota law, whereas the idea of being able to determine the benefits or compensation for an individual is necessary under federal law. If a supervisor engages in unlawful harassment but no tangible employment loss occurs, an employer can avoid liability by 1, establishing the affirmative defense that the employer took prompt remedial measures to address any harassing behavior. Or the other defense available to an employer is that it had no actual or constructive knowledge of the harassment. Well, what do we mean by constructive knowledge? Constructive knowledge means that the supervisor should have known of the sexual harassment given the circumstantial information in and around the supervisor. Employers can demonstrate taking reasonable efforts to prevent sexual harassment in these following ways. By drafting and publishing an anti-harassment policy, by providing sexual harassment training to employees, promptly investigating complaints of sexual harassment, enforcing the anti-retaliation provisions of its anti-harassment policy, and 5, disciplining employees who violate the company's anti-harassment policy. Let's take a moment to talk a little bit about retaliation. The Minnesota Human Rights Act prohibits employers from punishing job applicants or employees from asserting their rights to be free from employment discrimination, such as sexual harassment. Minnesota law also prohibits employers from punishing job applicants or employees for participating in activities that seek to eliminate employment discrimination, such as combating sexual harassment. When job applicants or employees assert their rights to be free from employment discrimination or to participate in activities that seek to eliminate employment discrimination, the individual does not need, Minnesota law recognizes that the individual has engaged in protected activity. So what do you mean by protected activity? Protected activity can manifest itself in many different ways, and I'll give you a couple of examples. The first way in which someone can engage in protective activity is filing or being a witness in an EEOC or Department of Human Rights administrative charge, complaint, investigation, or lawsuit. You can also engage in protective activity by communicating with a supervisor or manager about employment discrimination, such as sexual harassment, answering questions during an employer investigation of alleged harassment, refusing to follow orders that would result in discrimination or encouraging sexual harassment, resisting sexual advances or intervening to protect others, asking managers or coworkers about salary. So participating in the complaint process to support an employee coming forward is also protected from retaliation. So as we can see that there are a wide variety of areas in which courts have defined and interpreted what constitutes protected activity under the law. Employers should remember that an employee does not need to use the magic words or use specific legal terminology to be protected from retaliation. An employer is not allowed to do anything in response to protected activity that would discourage someone from resisting or complaining about sexual harassment. For example, depending on the facts, an employer could be engaged in retaliation when they reprimand or give an employee performance evaluation that is lower than it should be given the employee's performance. An employer could be engaged in retaliation when they transfer an employee to a less desirable position, when they engage in verbal or physical abuse with the employee, when they threaten to make or actually make reports to authorities, such as reporting immigration status or contacting the police, spreading false rumors, treating family members negatively by canceling a contract with the person's spouse, or changing the person's work schedule or assigning less desirable job duties. The bottom line here, any tangible job benefit being denied or eliminated by the employer can support a reprisal or retaliation claim. In the department, approximately about 20% of the charges filed with the department are reprisal claims. So let me share with you a couple examples of reprisal discrimination to illustrate the breadth of reprisal discrimination claims. In the first case, an employee who had filed several unsuccessful equal employment opportunity complaints subsequently sought a promotion within the organization. The employee learned that her manager had placed information about the previous EEOC proceedings in her personnel file and subsequently communicated that the employee had several complaints in her file when contacted for subsequent reference checks. The Equal Employment Opportunity Commission found that the statements made during the reference check process constituted retaliation against the employee. The EEOC also found that the EEOC information that was placed in the employee's personnel file was unnecessary and hindered her promotional opportunities. Let me give you a case from the Department of Human Rights. In a case called Sanford versus Volkswagen of Duluth, the charging party, a receptionist, was interviewed as a witness in an internal sexual harassment investigation. Approximately 2 weeks after the interview, the respondent posted an ad for 2 part-time receptionists. 3 days later, the charging party was terminated with downsizing listed as the termination reason. The department, after doing an investigation, found that the termination was causally connected to her participation in the sexual harassment investigation and that there was no structured, organized downsizing that had been planned by the employer. Sanford is a good reminder that reprisal claims can exist for witnesses and those who support individuals who have been subjected to discrimination. A quick recap here. First, all employees are protected under the law from retaliation. Second, employees who support coworkers who are allegedly harassed in filing a complaint or who participate as witnesses are also protected from retaliation. Finally, reprisal claims are independent. They are independent legal claims that can be brought against an employer. As reprisal claims are independent legal claims, a woman who is terminated after filing an internal complaint of sexual harassment may still have a viable reprisal claim, even if it's later determined that the underlying sexual harassment claim does not amount to sexual harassment. Let's talk about the steps that we can take to address sexual harassment in the workplace. And I'm going to tilt on the head probably how most of you have participated in sexual harassment training. And that culture is generally talked at the end, and there's a focus on investigation and policies. But if we're to be truly effective in eradicating sexual harassment, the company must first establish a culture of respect throughout the organization, creating a culture that is an inclusive environment for women, a holistic prevention program where harassment and retaliation is not tolerated. Please note that the emphasis is telling employees within the organization that senior management is committed to building an environment where all succeed. Historically, senior management has focused on combating sexual harassment with a more punitive frame. Employees who engage in certain behavior will be punished, and that punishment may include terminating the employee. Appreciating that a positive win-win in which all are included avoids creating adversity and animosity within the workplace. So, question. Does senior management within the organization regularly communicate internally as to why inclusion for all employees is valued? What a CEO or president communicates as important ultimately derives the direction of the organization. So are women valued in the organization? Meaningful efforts to curb sexual harassment can only occur when women are respected within the organization. Closely aligned with that are climate surveys conducted. The organizations that conduct climate surveys on a regular basis are in a much better position to understand how to facilitate organizational change and create an inclusive environment for all. Workplace civility training. When you hear the word civility, words that come to mind likely include respect, courtesy, tolerance, consideration, and a rational approach to conflicts. Many employees have implemented civility training in an effort to provide tools for their employees to positively and productively relate to others. In a survey published a few years ago by the National Institute for Occupational Safety and Health, approximately 25% of businesses identified workplace bullying. Again, it's probably not much of a stretch for us to appreciate that if we have an issue concerning workplace bullying, we might have an environment in which sexual harassment might be able to flourish. So how do we create a culture of respect? Are you regularly providing compliance training for employees? Are employees regularly informed about the conduct that constitutes sexual harassment and that they will not suffer reprisal? Employees that understand that they will not suffer retaliation are much more likely to feel comfortable to take steps to address sexual harassment that is occurring within the workplace. Do you have regular compliance training for the mid-level managers and frontline supervisors? Again, managers and supervisors that receive regular training are much more comfortable to be able to prevent and respond to sexual harassment complaints. So do your managers and supervisors understand how your commitment to a more respectful workforce, equal pay for women, and how your efforts in the area of diversity, equity, and inclusion are interrelated with your efforts to reduce sexual harassment? Supervisor performance review. Has the company implemented metrics for how managers and supervisors respond to and prevent harassment? Again, if we're saying that pay is an indicator as to what is important, shouldn't the employer indicate to its managers that part of what is important to them and how they're going to be measured is how well that they create an inclusive environment? Finally, an issue in creating culture is bystander intervention training. Well, what is meant by that? Bystander intervention is based on the idea that both men and women can interrupt behaviors that prevent sexual violence. I appreciate the work that has been done by the Minnesota Coalition Against Sexual Violence, which gives some suggested tips for bystanders. Approach everyone as a friend. Don't be antagonistic. Be honest and direct whenever possible. Recruit help if necessary, and keep yourself safe. If things get out of hand or become too serious, there's always additional help that you can call. When we are in the workplace and we see something that is amiss, do people feel empowered to step in and interrupt the bias that they see? Let me take a few minutes here and talk about anti-harassment or sexual harassment policies. Do your employees understand that the policy has been endorsed by senior management? If we look at the top of the pyramid here, consistent with our earlier comments regarding culture, your employees are only going to follow your anti-harassment policy if senior management has impressed upon everyone within the organization that the policy matters to senior management. Is the policy written in clear, simple words? Your policy is not effective if it's not understood by your employees. Is it clear to all employees where they should report incidents of unwelcome behavior? Does the policy describe prohibited conduct with examples? Don't assume that your employees know where to draw the line of inappropriate conduct. Often employers are chagrined to find out their employees don't understand what conduct is inappropriate. Including examples within your policy will help to clarify for employees what conduct and behavior is expected. Does the policy contain a clear, unequivocal statement that harassment will not be tolerated? Do your employees truly understand the consequences of their actions if they engage in prohibited conduct under your sexual harassment policy? If you feel that it is appropriate to terminate an employee, do you believe that you have provided adequate notice within your policy as to when that would occur? Multiple avenues for an employee to report harassment. Occasionally, the department will come across a situation in which the employer has only identified one person to receive a report of harassment. And that person, unfortunately, is the individual often that the employee believes is responsible for committing the sexual harassment in the workplace. Again, examine your policy. Do you have multiple avenues to report sexual harassment? Finally, does the policy state that the employer will provide a prompt, thorough, and impartial investigation? An effective defense to a sexual harassment complaint is that the employer took prompt remedial measures. One way to enforce and reiterate that throughout the entire organization is to be explicitly clear within the harassment policy. Remember, unreasonable delay by the employer in initiating an investigation can lead to a legal finding by courts or probable cause determination by the department for failure to take adequate and prompt remedial measures. Now, what happens, again, in the course of an investigation, and what steps should be taken when the employer becomes aware of sexual harassment? Again, the folks that are charged with the responsibility for conducting sexual harassment investigations and for mediating decisions should understand that it's important to take immediate and appropriate corrective action when taken. Unfortunately, we have investigated matters in which an internal investigation has revealed, say on Monday, that sexual harassment has occurred, but no action has been taken until Friday, and the alleged harasser and the alleged victim continue to work for 4 additional days. Again, everybody who is involved in the investigation proceeding should know that they need to take immediate and appropriate corrective action once the employer knows that sexual harassment or believes that sexual harassment has occurred. Does your internal policy and your investigation policy state that the identity of an individual who submits a complaint, a witness who provides information regarding the complaint, and the target of the complaint will be kept confidential to the extent possible through a thorough and impartial investigation? Remember, employees who fear retaliation are far less likely to report complaints of sexual harassment. In order to have your employees tell you that your workplace is intolerable by, one way that your employees can tell you that your workplace is intolerable is that they can vote by their feet and they can leave your organization. Make sure that you're proactive and inform all employees to come forward with their information. You want to keep them there. Appreciating the fact that all information may not be kept confidential, you will try and endeavor as much as possible to keep the information confidential during the course of the investigation. Does the policy state that an individual who submits a complaint or employees who support individuals who file a complaint or provide information during the course of an investigation will be protected from retaliation from coworkers and supervisors? Again, it's important for employees within the company to understand that their actions to eradicate sexual harassment will be supported whether they are reporting harassment, acting as a witness, or supporting someone who files a report of harassment. Employers can't expect that employees will come forward with complaints of sexual harassment until they appreciate that they will not be subjected to retaliation. Finally, does the policy state that an employee who engages in retaliation will be disciplined? Again, one of the most common charges filed with the department is a retaliation or reprisal claim. In order to minimize the risk of an employee engaging in retaliation, employers should be clear that they will not tolerate retaliation or reprisal, and that employees who engage in such behavior may be disciplined up to the point of termination. Let's talk about some tips on investigations themselves. Whether an employee comes to you with a seemingly small gripe or a complaint about egregious conduct, you are legally required to look into the matter and engage in a prompt and thorough investigation. There may be many reasons not to conduct an investigation, but to make it very clear here, there's really no good reason for failing to conduct an investigation. Every employer has probably confronted this problem at least once. An employee complains to a supervisor that a coworker engaged in inappropriate conduct, but asks the supervisor, just keep it between us for now. That's usually because the employee fears retaliation. In that situation, the supervisor should explain to the employee that the company will do everything possible to keep the matter confidential, but that it is important that all these matters be investigated. Employers should not promise absolute confidentiality, but instead state your intent to provide confidentiality to the extent practical. Supervisors and managers should be trained to assume personal responsibility for contacting human resources directly if they receive a complaint. If supervisors are not promptly reporting harassment complaints, you should consider informing them that they may be subject to employee discipline for failing to promptly report sexual harassment. Promptly initiate investigations. You may have all the right policies and your investigations may be thorough, but it's difficult to argue that you take harassment complaints seriously if you wait 2 months to start an investigation. Administrative agencies and courts may find that you have not taken proper remedial measures. Instead, initiate investigations immediately and complete them as soon as possible. If there are unavoidable delays, document the reasons for the delays and explain the unexpected challenges that have delayed completion of the investigation. Inform the concerned parties of the results once the investigation is complete, and where appropriate, a communication of the sanction imposed if harassment was found to have occurred. Imposition of discipline should be consistent and proportionate to the severity of the harassment. Oops. Sorry about that. Make sure that you also interview all potential witnesses. You should ask the complaining employee to identify any witnesses who might have relevant information. Also, you should interview coworkers of the accused who may be able to provide information about whether they have seen him or her engage in similar conduct. If coworkers have witnessed the alleged harasser engaging in sexually harassing conduct in the past, they can have a huge impact on the outcome of an investigation. Oftentimes, employers make the mistake of just simply interviewing only the alleged harasser and the victim. Make sure that you conduct a thorough investigation by interviewing all individuals who might have knowledge of what occurred. Also, don't be afraid to take interim remedial measures during the course of investigation. Too often, employers focus only on which remedial measures need to be taken after the investigation is complete. However, depending on the circumstances, you may need to take temporary remedial measures during an investigation. For example, in a sexual harassment investigation, the EEOC guidelines and case law suggest that you separate the complaining employee from the alleged harasser until the investigation is complete. However, that doesn't mean involuntarily transferring or increasing the workload of the complaining employee, which may be seen as retaliation. During the pendency of an investigation, employers should also have systems to ensure that individuals who have alleged to have engaged in harassment are not presumed guilty. It's also important during the course of investigating a complaint that you stay impartial. It's important not to prejudge complaints. In some cases, invalid claims are incorrectly filed because of a failure to comprehend the law or the applicable legal standards. In other cases, harassment claims are filed to retaliate against a supervisor or an employee dislikes, or maybe to possibly shield the employee from responsibility for his own performance deficiencies. Unfortunately, some individuals use sexual harassment laws as a tool to harass and retaliate against others who are themselves innocent victims of such claims. Make sure that you come into the process with an impartial lens. Until a claim is fully and carefully investigated, you should inform any conclusions about the guilt or innocence of the respective parties. Finally, make sure that you develop adequate documentation. Every investigation should be documented with the worst-case scenario in mind, and that is the investigator facing a cross-examination in front of a jury about every sentence in the investigation report. Reports should be thorough and thoughtfully written. Ideally, witness statements should be signed by the witnesses. When offering conclusions about a witness's credibility, the investigator should set forth the objective basis for his or her determination. For example, the witness's demeanor and motives, the extent of corroboration by other witnesses, or additional documentary evidence, or even history of similar accusations of conduct should all be documented within the internal complaint filed by the investigator within the company. Now that we have talked a little bit about the tips on conducting an investigation, your sexual harassment policy, and most importantly, making sure that you establish the right culture within your organization as a means to combat sexual harassment, let's take a few minutes to talk before we close today. What does the Me Too movement mean going forward? First, will there be more reports of sexual harassment? I think, yes, there will be more reports of sexual harassment, and there are two reasons for believing that there will be more reports of sexual harassment. The first reason that I offer for more reports of sexual harassment is more of a glass half full view of the world. This moment in time feels like a watershed moment in which more women will feel empowered to file more complaints, administrative charges, and lawsuits concerning sexual harassment, because they now know that they are not alone in reporting what they are experiencing. An example of one woman coming forward and having a positive impact and empowering other women to come forward within her company is when the department investigated a case of quid pro quo sexual harassment in which the supervisor was seeking to extract sexual favors from workers that were undocumented. Once the charging party came forward, several other undocumented women came forward with claims that they were being propositioned for sexual favors. The second reason that I offer for more reports of sexual harassment being filed is kind of more of a glass half empty view of the world. Before the Me Too hashtag went viral, the Equal Employment Opportunity Commission in 2016 published a report entitled Select Task Force on the Study of Harassment in the Workplace. That report indicated that harassment was significantly underreported and that many employees did not believe that it would be helpful for them to come forward and file a complaint. Accordingly, in this half-empty glass, there clearly will be more complaints of harassment because the number of complaints can only go up. Let me provide you with some of the statistics and findings provided within the report cited by the EEOC in 2016. One report cited by the EEOC noted that the common workplace-based response by those who experienced sex-based harassment was to avoid the harasser, in which nearly 75% indicated that that was their strategy. 54%, in addition to that, avoiding the harasser, tried to deny or downplay the gravity of the situation. In addition, several sought to ignore, forget, or just simply endure the behavior. Another study found that approximately 30% of the individuals who experienced harassment talked with a supervisor, manager, or union representative. In other words, approximately 70% of the individuals who experienced harassment never even talked with a supervisor, manager, or union representative about the harassing conduct. And some of you may be aware of the recent New York Times article discussing harassment within the Ford plant. Another study cited by the EEOC found that gender harassing conduct was almost never reported. Unwanted physical touching was formally reported only 8% of the time, and sexual coercive behavior was reported by only 30% of the women who experienced it. So in some ways, we have been in a point in time within our nation's history that sexual harassment, despite being declared a hostile environment under the Meritorious Savings Bank case from 1986, we don't really have a lot of complaints of sexual harassment being filed. My feeling is that, and I think it's borne out by these studies, is that there is still a culture which suggests that women are going to be ostracized or not fully supported when they come forward with complaints of sexual harassment. So again, this really underscores the importance of creating a culture of respect within the organization to really ferret out and to address sexual harassment which is occurring within organizations. I think the emerging question, too, would be, should the standards for what constitutes a hostile environment be reevaluated? Many believe that the standard for what constitutes a hostile environment is too high. And again, our earlier conversation, remember, it is a subjective and an objective standard that courts are applying. An example of a case in which some advocates view as constituting too high of a hostile environment is Duncan versus General Motors. I offer Duncan, the Eighth Circuit case, for discussion, not only because it is clearly, not because it is clearly understood sort of as a seminal case on sexual harassment, but rather that it's a fair representative case of the cases that illustrate for advocates that the standard for hostile environment is too high. In Duncan, the allegations of sexual harassment included the following. The alleged harasser asked the employee if she wanted to have a sexual affair with him. She rejected his advances, and he subsequently apologized. The alleged harasser asked the employee to assist with something on his computer. The alleged harasser's screensaver was a photo of a naked woman. The alleged harasser had a planter in his office that was shaped like a slouch man wearing sombrero. The planter had a hole in the front of the man's pants that allowed for the cactus to protrude in what the alleged harasser believed was a sexually explicit manner. On one occasion, he asked the the victim to draw the planter into his office. The alleged harasser kept a child's pacifier that was shaped like a man's penis in his office that he occasionally showed to his coworkers, and on 2 occasions he showed to the employee. And he also displayed pictures of the employee as the president of the Man Haters Club of America. So I will ask you, do you think the following facts constitute a hostile working environment? In Duncan, the district court found that the conduct amounted to sexual harassment. The Eighth Circuit, however, found that the conduct in Duncan failed to amount to sexual harassment. Again, I don't offer up Duncan to say that it is the seminal case on sexual harassment, but I do think it is one of the cases which are cited by advocates in which they believe that the average reasonable standard has been interpreted too high and is limiting or preventing meritorious sexual harassment claims going forward. The final point here, and then I will take it for questions, is the internal investigation process broken within organizations? Many of the individuals, and this goes back to the EEOC report, believe that human resources was not there to conduct a fair and impartial investigation, but was merely there to ensure that their sexual harassment claim did not go forward. So again, if employees are feeling that they don't really have a true resource within human resources to come forward with their complaints, they may not make the decision to file a complaint. That may then result in the workplace becoming less effective, and it also may result in employees leaving your place of employment. Some individuals out there are suggesting that the only way to repair this breach of trust is for investigations to be done by an independent third party, or for somehow to segregate human resources from the rest of the organization. Again, I offer this up not to suggest that this is the way in which all employers should go, but this is likely going to be a question which is going to be out there and which employers should be thinking about. And with that, I will take a breath here and get a little drink of water, and then I will be ready to take on any questions which have been sent to me.
Thank you. Please type your questions into the chat box, and we will collect them and have the Commissioner respond.
So I see that we have 3 questions. The first question, does sexual harassment include shaming or negative body image comments and innuendo? So the answer is sexual harassment can constitute shaming or negative body image comments and innuendo, but I will go back to the discussion within Duncan, is that you have to apply the objective standard, and there are some cases out there in which there is a split of opinion on how severe and pervasive the conduct is and whether it rises to the level of meeting the sexual harassment standard which has been set forth. Isolated statement which is made on body shaming or innuendo likely is not to meet that standard. Multiple comments over a period of time, the more sexually explicit possibly the comment, the situation in which the comment is made, if it is a one-on-one comment, or is it a comment in which several other employees are within the room at the point in time? The relationship and dynamic between the respective employees, is it a manager versus a subordinate? Is it a coworker? Or is it a subordinate to a senior level individual? All of those elements, all of those facts would weigh in on the decision on whether this would constitute sexual harassment. The second question, which was asked, examples of appropriate or corrective action after a complaint has been filed. And that could take the shape in many different directions. Sometimes it is sufficient just simply to separate the two employees. A word of caution, there is a case, Jack Links, that we have within the office in which the company did an internal investigation, found that sexual harassment occurred, separated the two employees, and then 2 weeks later they promoted the supervisor, so the supervisor was then again responsible for having the person who had come forward with the sexual harassment report to him. And unfortunately, the bad behavior which had been identified began again. So make sure that if your proper remedial measure is to separate the employees, that you come back a couple weeks later or a couple months later to make sure that it has actually been effective and it's actually abated the sexual harassment or the bad behavior. Sometimes it can be an economic penalty in which the employer can impose by demoting or transferring a harasser to a less prominent position. And obviously there are times in which the conduct is so severe that the appropriate reaction by the employer is to terminate the employee. But please do appreciate that there is a wide range of remedies available for the employer. And the key thing that courts and I would say administrative agencies are most keyed in on is whether the sexual harassment stopped after the remedial action was taken. And if you're the employer, once you've taken that proper remedial measure, make sure that you check back in with the person who brought the initial sexual harassment claim to make sure that the sexual harassment did in fact stop. The third question which has been forwarded is who should conduct investigations, and the question there is whether it should be human resources. I don't subscribe to the theory that human resources should not be involved. I, again, want to make sure that my comment there at the end about emerging issues is properly framed and understood. I think that there will be some conversation about whether human resources should continue doing investigations or whether it should be an independent third party. But I don't come to this conversation saying it always should be an outside party and that human resources can't do an investigation. I think if you're looking at that question and going back and ensuring that you want to create a culture of respect and inclusion, and you've been doing climate surveys, if you feel that human resources is a trusted partner among all employees, by all means, they should be the ones conducting an investigation, and they should be empowered in a way by senior managers such that they're supported, in that any determination which they make is that senior managers are going to support that, whether they find that sexual harassment did occur or did not occur, and that they should be part of the solution for addressing and making sure that it's an inclusive work environment going forward. The next question that I received is there a standard form we should have on file for complaints? There are probably some, there's no legal requirement that there needs to be a form specifically filled out by an investigator in doing an internal sexual harassment investigation. What I would suggest, though, for employers is that they be very clear concerning what the alleged harasser is setting forth as to what constitutes sexual harassment. So if we think about what we learned when we were taking our journalism class of who, what, where, when, and how, all of those questions should be incorporated within the initial document that you create when you sit down and meet with the person who's coming forward with the alleged harassment, so that you have properly framed what they are saying to you constitutes harassment. The form should, or your note should identify who may have knowledge and what documentation either supports or helps you understand whether the sexual harassment occurred. And by documentation, the most common, I think, example of that would be timesheets of when people worked and where they worked within a particular building. Some people might say, for example, Lindsey might say, I did not work there, and therefore I could not have sexually harassed Christine. Well, obviously, if the payroll records indicate that, in fact, Lindsey was working within the building, that may be very helpful for you making a credibility determination on who you believe in that sexual harassment scenario. The next question is, how do you handle a situation of harassing conduct that occurs off-site, for example, at a happy hour? And does an employer still have an opportunity, or does the employer still have an obligation to investigate? In that situation, there's still a duty for the employer to investigate. Again, the dynamics of what occurred within the setting may color the way in which you evaluate whether it constituted sexual harassment. So to the extent that the male employee was saying that he was sexually harassed by his female manager, and there had been some overtures by the male employee to set up the meeting off-site for the happy hour, there was some discussion of the behavior being welcome or encouraged by the male employee. That may color your ultimate determination of whether sexual harassment occurred. I do want to be very careful here, though, to suggest that that setting in and of itself does not necessarily mean that anything that occurs in a happy hour setting could not constitute sexual harassment, because it is clear that there's case law that supports that that setting by itself does not change the calculus of whether sexual harassment occurred. The next question: how long can you file a complaint? So, yeah, I'm assuming that goes to the Department of Human Rights. So again, with the Department of Human Rights, you have a year. Under federal law, it is 300 days. So an individual may feel that they were sexually harassed, say on day 1, day 301 comes by. What has now happened is they may have lost their ability to bring a claim under Title VII under federal law, but they would still have several days in which still to bring a claim under the Minnesota Human Rights Act. The vast majority of the complaints that are filed with the department are not filed in that last 60 to 65-day window. Most of the complaints are filed within the first couple of months after the incident of harassment or discrimination. I'm going to take one more look around in my proverbial inbox here and see if there are any other questions, and if not, then I might turn it over to Christine. I appreciate all the questions which have been sent in, and I hope that the information today has been helpful for folks. And if there are additional questions that people have, please feel free to send an email to the department, and then we can follow up as well. Let me take one more look within my inbox here to see if there are any additional questions.
Thank you for joining MnDHR and Commissioner Lindsey today. You will find more information on MnDHR's website, including other videos from the Webinar Workforce Series. We will follow up with an email to registered attendees once we have a video that's ready to share of today's presentation. Thank you so much for your time. Have a great day.